My name is Mike Gilleran. I'm an attorney. How's that? I'm not going to sing anything, I promise. My name is Mike Gilleran. I'm an attorney in Boston, and I've dealt with this issue for quite some time. To me, there's two key points here. Erica brought them up. One is this, I think, is the civil rights issue of our time. It is also an issue that is ripe for people who dissent from the aggressive secular orthodoxy of our time. And I'll explain what I mean as I go along. I myself am the product of, let's just say, very, very good schools. I went to the College of William and Mary in Virginia, and I went to law school in New York City at NYU. I'm a partner at a major law firm in Boston. I've written books which are often quoted by our state Supreme Court. I've written articles which appear in the American Bar Association Journal. I have been the product of very, very, very good schools. At the same time, I am the grandson of an Irish immigrant to this country who came here as a pauper, without money, without anything. He was later deported back to Ireland without money, without anything. And I am also a Catholic. And in addition, I am a former aide to Raymond Flynn, the Catholic mayor of Boston. And I'm aware of this city, its history, its hates, its discriminations, and the struggles therewith. I have campaigned in all the neighborhoods of this city. I know what goes on around this city, and I bring a lot of history to this talk today. Now, let us go. I'm going to tell you something about the Blaine Amendment in Massachusetts, how we got here, and where we should go from here. I'm going to hand out some things, if I might. Jamie, I'm going to leave this all to you.
Thank you.
The beginnings of this issue in the Commonwealth of Massachusetts are really striking. And they start with the 1780 Constitution written by John Adams. And the 1780 Constitution has two sides to it that are remarkable. If you look at the first page of what I've handed out to you, I include part of that 1780 Constitution, which says that the state and the towns and the cities shall provide support for Protestant teachers of piety. Okay, only Protestant support, only Protestant teachers of piety, not Catholics, not Jews, not any other kind of religious dissenters. But then it says something very interesting. And all monies shall be uniformly applied to the support of the public teachers of his own religious sect or denomination. So what Adams wrote, which is, of course, limited to his own time and place of Protestant teachers of piety, but among Protestants, you could take the money, essentially a voucher, and take it to your congregational school or your Episcopalian school. I admit, from a Catholic point of view, this is pretty limited, but nonetheless, you got a choice where you were going to take this money. And a complete copy of this 1780 provision from the Constitution at that time is on the second page. You can look through it. It's really striking, the level of tolerance that Adams had. But then things began to change. And those things began to change in the 1840s, when huge numbers of Irish, my family's from County Roscommon in Western Ireland, which was an area of huge famine. And if you know much about the history of that time, people died on the streets without comfort, without food, without anything. And often, by the way, they did have one hope. If they would drop their faith, maybe some of you know these stories, it's called taking the soup. If you would give up your faith, you would live. We'll feed you. If you don't, you die. That's it. That was the choice. Take the soup. Among people like me, we know this phrase. We know what it means. And that was the choice they had. And those that didn't take the soup took the boat. And they came to this country, and they came to this city, not this city, the city across the Charles, in large, large numbers. By 1845, 1846, 25% of the people of the city of Boston were of Irish Catholic heritage. A few years later, it was a third. Now, you've got to remember, in those days, Boston did not include places like West Roxbury or even Charlestown or Dorchester or West Roxbury. Boston was a much smaller place, largely the North End, East Boston, South Boston, and Back Bay and South End. That was it. And in that smaller area, there was a huge number of people who'd come here who were poor, who were uneducated. They were mostly farmers, but they had one thing they could do. They could read English and speak English, largely. They could do that. So this was a huge change for a population which was used to Protestant piety. Let's face it, it was a big, big change. And so there was a huge resistance to this change, and it resulted in something called what we today refer to as, they refer to themselves then as the Know Nothing Party. They had another name. They were the Native American Party. But if you asked a member of the Native American Party, did they belong? They would say, I know nothing. And so that's what it became known as. And it became very, very powerful. Now I'm looking at the platform of the Native American Party of 1855, and it says, this is not what you've got there, it says, resistance to the aggressive and domineering tendencies of the Catholic Church is our platform. Resistance to Catholic immigration, the Catholic Church, that's what they stood for. And they became a huge political organization and had huge numbers in the Commonwealth of Massachusetts, including nationally. And in 1854, they ran, as Jamie discussed, they ran their candidate for governor, whose name was Gardner. They took over both houses of the government, the Senate and the House of Representatives, both, and they began to change the Constitution from the 1780 version of John Adams, which was tolerant, at least tolerant, and they put in its place two things. And this is the first page of what I've given you, and it's on the right-hand side. And this is what we call a proto-Blaine Amendment. This is before the Blaine Amendments, and I'll talk about those in a minute. And this did two things. It said, one, all money for us, for the Protestants, all the money goes to us. I'll explain what I mean by that. And no money for you. Here's what I mean by that. The first part is all money for the support of the common schools, no other schools. The common schools taught, this is, you may doubt what I'm about to say, taught Protestantism. The Bible was Protestant. It was the Protestant version. Bible reading itself in the Catholic faith at that time, without the mediation of the church, was viewed as not right. And students who didn't agree to read the Bible, the Protestant Bible, or sing the Protestant hymns, or engage in Protestant observances, were subject to corporal punishment, to beating. At least they weren't starved to death. They were only beaten. And this is what the Know-Nothings did in 1855. So all money for us, not for you. And no money shall be appropriated by any religious sect, of course that's Catholics, we're the sect, for the maintenance exclusively of its own schools. Sect was a code word for Catholic. Now, this was the first of this type to be enacted in this state, as in any state. In other states it came later. But the history, as I've explained it to you, is not just my own view. This is not just my own view. In Zellman versus Harris, the 2002 decision that Erica talked about, Justice John Paul Stevens described this history as follows. Dreading Catholic domination, native Protestants terrorized Catholics. In some states, Catholic students suffered beatings or expulsions for refusing to read from the Bible, and crowds rioted over whether Catholic children could be released from the classroom during Bible reading. Catholics sought equal government support for the education of their children in the form of aid for private Catholic schools, but the, quote, Protestant position on this matter was that schools must be non-sectarian, which was usually understood to allow Bible readings and other Protestant observances. And public money must not support, quote, sectarian schools, which in practical terms meant Catholic. And this sentiment played a significant role in the creating of a movement that sought to amend several state constitutions, often successfully, and to amend the U.S. Constitution unsuccessfully, to make certain that government would not help pay for sectarian, that is, Catholic schooling for children. Now, this is John Paul Stevens, so you can see what I said is really the common view. It's not just my own personal view, it's not some sectarian view. This is the common view of what happened in those days. So Massachusetts got its proto-Blaine Amendment, and then about 20 years later, similar amendments were proposed for the U.S. Constitution, and that amendment put forth, as Jamie said, by James G. Blaine of Maine, who was also the Speaker of the House at the time, had took a similar form but somewhat different wording, and the form it took, if you can look on the last page, and you'll see there, the last page is the types of Blaine amendments that exist, and the first one there is the federal Blaine, and you can see there, this, by the way, these charts, I'll explain them in a minute. They from the left, I'll explain them in a minute, but the federal Blaine required that no public money shall go to any school controlled by any church, sect, or denomination, and there shall be no sectarian instruction. Now, the Blaine Amendment passed in the House. You may recall how you amend the Constitution. You've got to first get it through the House and the Senate, then take it to the states. But it passed in the House and only lost by 4 votes in the Senate, so it was close. It was close. And so that was the first Blaine, that was the Blaine Amendment, and then what happened then is the Know-Nothings and their successor party called the American Protective Association, after the Know-Nothings were opposed by people like Abraham Lincoln, opposed strongly by people like Abraham Lincoln and others. They began to retreat. But they reappeared many years later and were called the American Protective Association. Sounds like the word of protective is very close to Protestant, which is what they were. They sought to enact laws in many states, including Montana, which provided that there shall be no teacher which is under the influence of a, quote, foreign ecclesiastical power. Now, you know what that means. If you're a Catholic, no Irish need apply. You're not going to work here. You can't even have a job. That was the American Protective Association. Their numbers grew in Massachusetts to over 100,000 members by the 1890s. By the way, by the 1890s, there were over 8 million Americans of Irish Catholic descent. Huge, huge numbers, and in our state of Massachusetts as well. So that's the federal Blaine Amendment. Montana Act enacts one in 1890, which was required by the Enabling Act passed by Congress in 1889. You can only become a state unless you pass a Blaine Amendment. And of course, Massachusetts already had its own Blaine Amendment. So you can see the kinds of clauses they have, these Blaine Amendments, on the top chart there. And basically, they said the same old thing as I explained: all money for us, none for you. Just a simple way of understanding it. Now, I could go through the permutations of the Massachusetts Blaine Amendment or Anti-Aid Amendment since it was first passed, but that's not really a useful exercise for tonight. What did happen, just very briefly, was Irish political power began to manifest itself in the state in 1914 when the first Catholic governor was elected. And elements of the American Protective Association and other Protestant groups in Boston allied themselves together to further cement into the state constitution protections against potential support for Catholic schooling in the legislature by way of statutory enactments, and they did that. And that is the regime we're under to this day, which prevents exactly this type of tax credit from being enacted in the state of Massachusetts, but that's another question. So this lower chart here is, you can take a look at this. I put this chart together, and it basically tracks on the left-hand side what Erica talked about, which is what is permitted or perhaps even required under the free exercise clause. The far left case, which we already heard about, is the paving of parking lots. And of course, under the free exercise clause, that's required, or also the 14th Amendment, which prohibits discrimination solely on religious grounds. In the second column, you can see things like, do Blaine amendments prohibit use of state funds, public funds for busing to school, for school nurses, for school textbooks? And the answer is most Blaine amendments permit this, but some don't. Some don't. Even secular textbooks. There's a case in Massachusetts where the legislature, again, at the time Catholic, tried to have a loan of secular textbooks to Catholic schools, and the state Supreme Court said, no, that's a violation of our Blaine Amendment. So that's under our Blaine Amendment, the use of loaning of secular textbooks is prohibited. Now, the center one, we can see, is our case today, which is Espinoza, tax credits for scholarships to private or religious schools. Most Blaine amendments, including Massachusetts, will probably prohibit that. If Espinoza is successful, they'll be permitted. And you can go read across the page. The far right column is Locke v. Davey. Locke v. Davey, which is use of public funds in some form to attend a seminary, which I think most people would agree would be a kind of establishment of religion. Now, I started out by saying that I think this issue is a civil rights issue, and it's also an issue of religious dissent. And what I see myself, and why I've been so involved in this issue for so many years. By the way, I started out with this issue over 20 years ago when I was asked to help amend the state constitution to water down or get rid of our Blaine Amendment. And what happened at that time, a man named Cornelius Chapman was heavily involved, and others like myself were involved. Also, State Senate President William Bulger was a major force behind that effort, as well as Ray Flynn. And we got the signatures we needed to put it on the ballot for a constitutional change. We got the signatures. But several of our petitions had squiggles and doodles on them. Perhaps some of you have heard about this case. And the teachers union attacked our signatures and said they can't go on the ballot because some of their papers, some of their petitions have squiggles and doodles on them, which could be hidden Christian symbols. I'm not kidding when I tell you this. The case is Walsh versus Secretary of State. You can look it up, decided by the SJC. The SJC decided the squiggles and doodles could be some kind of something, who knows? And those petitions that had squiggles and doodles, I'm not kidding when I'm telling you this, I know it sounds absurd, were disallowed by our state Supreme Court, and we did not get on the ballot, and we failed. And so that brings us to the Espinoza case to this day. Now, civil rights and religious dissent, my own view. Almost all of us in this room are the product of excellent educations that we got through the grace of our parents, maybe their status in life, who knows? We got them. And there are so many we see in our urban areas today who don't have that chance and who are never going to have it. I drive around the city of Boston sometimes, quite often, and I'll see older black men, and maybe they're not going anyplace. Maybe they don't know what they're going to do that day. Maybe they have no job. And I say to myself, how am I more virtuous than these people who didn't get a chance? Like I had a fantastic chance at excellent schools. Why didn't they get that? And if they didn't get it then, why can't their kids get it? Why can't their children or grandchildren today get that chance? And we know in New York and other places, Catholic schools have done a fantastic job of educating poor children, or at least children who have some resources, that JV pointed out, Some resources, and as Mr. Peterson pointed out, some resources, they can do it. I read recently about a program in New York City where, I think it was in the charter schools there, where inner city minority kids overachieved in math and other areas, kids in Scarsdale. Wow. That can happen with the right kind of schools and with the right kind of teachers. We cannot have another generation of inner city minority children fail. We cannot do that. My last issue, which is religious dissent. My own kids went to Wellesley High School in Wellesley, Massachusetts, west of here. Increasingly in the last 5 or so years, there's been an aggressive secularism, and I'm not a secularist. I'm a vice chair of a Catholic college. My wife is a product of Catholic schools. Our religion is important to us. But increasingly, the schools where my kids went, a secular orthodoxy is preached, not only preached, is indoctrinated. And for a religious dissenter like me, there's got to be something else where kids who maybe don't have the resources I've got, parents can send their children and not be aggressively indoctrinated into a secular faith that they don't believe in. This is a fundamental issue of our time. I sure look forward to the Supreme Court decision. I'll be there that day. I expect huge crowds of people who are opposed to the potential decision will be there. But I sure look forward to the result and a better world for inner city kids and for religious dissenters. Thank you.